Check. Test 1, 2.
I gotta feel the support. I did have on socks, but it felt weird, so I took them off. Gotcha.
The Department of Mental Health and Substance Abuse Services Board meeting to order. Thank you all for being here today. I know we have some travelers, and I think we're still expecting another member or two of our board to join us, but we do have a quorum, I believe. Is that right? Okay. I'd like to, before we get started this morning, ask everyone to stand and say the Pledge of Allegiance. Pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all. Okay. I'd like to, I'm sure all of our board has had a voluminous opportunity to read through the minutes that were sent out. Are there any questions about that? And if not, I accept a motion to approve.
I make a motion.
Second.
Thank you. Any comments? Hearing none. All in, or better yet, why don't you call the roll? Sorry.
Mr. Reinmiller?
Yes.
Let's see. Mr. Moore?
Yes.
Dr. Ali?
Yes.
Ms. Stomperud?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
All right, thank you. Moving on, I'd like to ask Ms. Reed to come forward and walk us through the program certifications.
Good morning. Okay. In the category of alcohol and drug treatment programs, we are recommending permit for temporary operation for the following programs: Firefly Outpatient LLC out of Norman, Tunnel Vision Recovery LLC out of Cache, Work It Health PLLC out of Norman.
Thank you. Do I hear a motion to approve?
I make a motion.
Thank you. And a second? Thank you. Would you call the roll, please?
Mr. Reinmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ali?
Yes.
Ms. Stomperud?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
In the category of alcohol and drug treatment programs, recommending certification with special distinction for the following program: Creoaks Mental Health Services, Inc., out of McAllister.
Thank you. Is there anybody from Creoaks here? Okay, Creoaks was 100% compliant in all standards and is eligible to receive a refund of their certification fee. So, do we have a motion to approve Creoaks?
Make a motion.
Thank you. And a second?
Second.
Thank you, Dr. Wilsey. Would you call the roll, please?
Mr. Reinmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ali?
Yes.
Ms. Stomperud?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
In the category of alcohol and drug treatment programs, we are recommending certification with distinction for the following programs: Community Strong Counseling, LLC, out of Lawton, Family Development and Intervention Services, Inc., out of Oklahoma City, Jim Wallace and Associates, Inc., doing business as Jetty Counseling Center, out of Wynnewood, Pivot, Inc., out of Oklahoma City, Rogers County Drug Abuse Program, Inc., out of Claremore.
Thank you, Ms. Reed. Anybody from any of those organizations here today? No? Okay. Well, Community Strong Counseling, Family Development Intervention Services, Jim Wallace and Associates, Pivot, and Rogers County Drug Abuse Program, all 100% compliant and eligible to receive a refund of their certification fee. So congratulations to all of them. Do I hear a motion to approve?
I make a motion.
Thank you. And a
Second.
Thank you. Call the roll, please.
Mr. Reinmiller?
Yes.
Dr. Jean? Oh, she's not here. Mr. Moore?
Yes.
Dr. Ali?
Yes.
Ms. Stomperud?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
Category of alcohol and drug treatment programs, we are recommending 2-year certification for the following programs: Grand Lake Mental Health Center, Inc., Grand Addiction Recovery Center out of Tulsa, Life Changes Wellness Counseling, Inc., out of Oklahoma City, Oklahoma Recovery Center, LLC, doing business as South Coast Behavioral Health Care, out of Oklahoma City, Summit BHC Oklahoma LLC, doing business as Bel Air Recovery Center, out of Oklahoma City.
Thank you, Ms. Reed. Do I hear a motion to approve?
I make a motion.
Thank you. And a
Second.
Thank you. Call the roll, please.
Mr. Reinmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ali?
Yes.
Ms. Stomper?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
In the category of opioid substitution treatment programs, we are recommending certification with special distinction for the following programs: Northeastern Health System out of Tahlequah, Oklahoma Treatment Services LLC doing business as Right Way Medical of Bartersville out of Bartersville, Oklahoma Treatment Services LLC doing business as Right Way Medical of Ponca City out of Ponca City, Southern Oklahoma Treatment Services, Inc., doing business as Oklahoma Behavioral Health Services out of Lawton.
Thank you, Ms. Reed. Do I hear a motion to approve?
I make a motion.
Thank you. And a second?
Second.
Thank you, Dr. Wilsey. Call the roll, please.
Mr. Reinmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ali?
Yes.
Ms. Stomper?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
In the category of outpatient mental health treatment programs, we are recommending permit for temporary operations for the following programs: Behavioral Wellness and Care Team of OK LLC out of Dell City, Joy Therapeutic Services LLC out of Stroud, La Vida Fearless Counseling PLLC out of Oklahoma City.
Thank you, Ms. Reed. Do I hear a motion to approve?
I make a motion.
Thank you. And a second?
Yes. Second.
Thank you. Would you call the roll, please?
Mr. Reinmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ali?
Yes.
Ms. Stomper?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
In the category of outpatient mental health treatment programs, we are recommending certification with distinction for the following programs: Amazing Skills LLC out of Tulsa, Central Focus LLC out of Wilburton, Jacobs Counseling Group LLC out of Oklahoma City.
Thank you, Ms. Reed. Is there anybody here from Central Focus or Jacobs? No. Okay. Well, they are both 100% compliant and eligible to receive a refund on their certification fees. So thank everybody from there. Do I hear a motion to approve?
I make a motion.
Thank you. And a second?
Second.
Thank you. And you call the roll, please.
Mr. Reinmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ali?
Yes.
Ms. Stomper?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
In the category of outpatient mental health treatment programs, we're recommending 2-year certification for the following programs: At Ease Counseling Services PLLC out of 4 Acres, Life Changes Wellness Counseling LLC out of Oklahoma City, the Laguna Group LTD LLC out of Oklahoma City.
Thank you, Ms. Reed. Do I hear a motion to approve?
I make a motion.
Thank you. And a second?
Second.
Thank you. Would you call the roll, please?
Mr. Reinmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ali?
Yes.
Ms. Stomper?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
In the category of outpatient mental health treatment programs, we are recommending 1-year certification for the following program: Summit BHC Oklahoma LLC doing business as Bel Air Recovery Center out of Oklahoma City.
Thank you, Ms. Reed. Do I hear a motion to approve Summit?
I make a motion.
Thank you.
Second.
Thank you.
Mr. Reinmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ali?
Yes.
Ms. Stomper?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
In the category of community-based structured crisis center programs, we are recommending certification with special distinction for the following programs: Oklahoma Mental Health Council, Inc., doing business as Red Rock Behavioral Health Services out of Oklahoma City, Oklahoma Mental Health Council, Inc., doing business as Red Rock Behavioral Health Services out of Oklahoma City, Shawnee, and Norman.
Is there anybody from Red Rock here with us today? Ah, fantastic. Congratulations. You guys are 100% compliant. You get all your certification fees back. Thank you for all the good work you're doing. Okay. Do I hear a motion to approve?
I make a motion.
Second.
Thank you.
Mr. Reinmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ali?
Yes.
Ms. Stomper?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
In the category of community residential mental health programs, we are recommending certification with distinction for the following programs: Chase E. Inc., doing business as 3C Old Fashioned Boarding Home out of Prague, Spears Management Co., Inc., doing business as Firm Foundation Residential Care Home out of Boley, Sugar Mountain Retreat, Inc., out of Welling.
Is there anybody here from Firm Foundation? also 100% compliant. So thanks to all the folks over there for the great work they're doing. Do I hear a motion to approve these three?
I make a motion.
Thank you. Thank you.
Mr. Einmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ali?
Yes.
Ms. Stomper?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Okay. Thank you, Ms. Reed. Everything, does that cover everything?
That's it.
That you guys do amazing work.
Thank you.
You cover a lot of ground all the time, so appreciate all that you're doing.
Thank you so
And
much.
to all those that are here and aren't, thank you for the tremendous work you're doing in our communities across Oklahoma. Okay. I'd like to move forward and invite Commissioner Slawacek to give us an update.
Thank you, Mr. Chairman. It's been a busy month. Had the opportunity to travel around, went up to OFC, visited with Holly and her team up there. We've had our consultants in on the consent decree. They were here yesterday, had a good meeting with them. Have visited Red Rock's CEO, Verna Frost, went to Tulsa, TCBH with our CEO up there, down to Norman to visit with our team down in Norman, Paulette Grimes and Brianna Norman. Went to OSU, had a meeting with Dr. Hess on a issue having to do with our foundation. Visited with the CEO of Family and Children's Services in Tulsa, and several others, including Steve Buck with Care Providers of Oklahoma, and then had an opportunity to go spend at least 2 meetings with Sue Ann Arnell with the Arnell Family Foundation. In addition, have met some of my colleagues, Ellen Butner with Oklahoma Healthcare Authority, had 3 meetings with Senator Paul Racino on healthcare issues, visited with Senator Chuck Hall on our appropriations budget as we move forward. I've had a couple of meetings with Rick Rose, who is in his final days. As you know, the COO, the governor appointed David Ostro to replace him, so he's on board. Had a meeting with the city manager, Craig Freeman, and have also, I would add, have had 2 meetings with our state legislators in this very room to talk about the programs that we are looking at either not funding or reducing funding or doing away with. And all because we have to work within our budget that we've been allotted. And we all know that we have budgets for our families and our businesses, and you can't spend more than you don't have. And that's been the challenge in my first 100 days, is trying to identify those programs. And so that's been a challenge, but my team, several are here in the audience today, have done yeoman's work in getting us to where we need to be. And I told the providers when I met with them that this is going to be a painful process. I told the legislators that, and so there shouldn't be any surprises. And I know that meetings that I've had, while they're not real happy with the decisions that have been made, we made those decisions, and now we're moving forward. Regarding the budget, I've eliminated 23 executive positions. These were outlined by the state auditor. We've adhered to and looked at the Loft report and many of their recommendations, and we're trying to use that as a roadmap of things that this agency should do that hasn't been done, especially on the financial side. And to that point, I hired a CFO, Ben Scott, who is here. I hired a new legislative director, who is Madison Miller, and I hired a new comms director, Jennifer Hogue. So I basically have the team in place to move forward, and all of these positions are critical to the success of this agency, in my opinion. Now, I know it's been reported in the media that we may be cutting essential critical services. That is not the case. We still cover all 77 counties, and of course, as you all know, 988 is that critical area with mental health lifeline that people can reach out, that's still in place, and we still can take care of those that are in crisis. I would also say that we are headed in the right direction, I feel. And as I mentioned to you before we began the meeting, that I have a meeting at 11 o'clock on Monday with the governor to brief our budget. And what I did at ODVA with the commissioners that I reported to is that I provided them a full set of financials at every meeting. That has not happened yet with this group because our budget, one, has not been approved. I want to get that approved, and then we will share that with you and take your questions. We are still receiving invoices from 25. That is not good. And so in some cases, when we're asked to pay bills, we haven't received the invoices, so we're having to get those invoices before we can pay those and reconcile the books, et cetera, et cetera. As you know, we were given an allotment for 26. We're working through that right now, and as you know also, we're required to go over to OMES every month and work with the CFO of OMES to allow them to give us our allotment each month. So that bill that's in place will stay in place, according to Senator Racino, through the foreseeable future, through the next legislative session. And so I think if I were the legislature, I would draft a bill like that, and maybe other state agencies need to do that as well. So I know that's not going to make my colleagues happy, but we went through the team when I arrived, as I may have mentioned, we had 800 contracts that we had to go through, and I was not going to sign off on those 800 contracts in 3 weeks because I'd only been on board. I wanted to make sure we went through every one of them, line by line, and it was a painful process. But there were things that we found, there were redundancies, there were grants that timed out that we still, the agency felt were needed, and we're having to draw money from other programs that we had agreed to. And so the decision had to be made, was that contract that we decided not to fund, did it fit our core mission? And so after several conversations, decisions were made. And in full transparency, I invited the state legislators, leadership, and anyone who wanted to come to those sessions to see what we were doing and how we were doing it, and the critical eye that we placed on all those programs to see if, in fact, they were needed. I would only wrap up my comments, Mr. Chairman, by saying that I feel good. I feel good about where we are. I feel good about moving forward. The staff here at DMH, there were cultural issues. I think we're working through those. And I would allow the media to go talk to any staff members anytime they want, any legislators anytime they want. We'll certainly make them available. But at the end of the day, my door is always open. My first month here, I had people arriving at 7 o'clock wanting to talk to me. I talked to them. And so it's a process, and I want to change the culture. I want to make sure that people that are here want to be here, that they want to work here. And quite honestly, unlike the military, if you don't like someone you're working for, there's not a whole lot you can do about it. So here, you have choices. Life's about choices and consequences. So I want people to be here that actually want to be here and work here and be part of the team. So with that concludes my report, Mr. Chairman.
Commissioner, I would be remiss in not saying what you stepped into in saying yes to this appointment was a lot. And you've put together a team of folks and brought here a team of folks that, in my interaction and my exposure to, has been very impressive. I know there were a lot of tough decisions, whether it related to internal staff or to programs that have been very difficult, and I just want to, on behalf of me and I believe on behalf of the rest of our board, thank you for your devotion to the mission, to serving the people of Oklahoma there in mental health crisis and need. Thank you very much for your candid comments. Okay, I would, any questions, first of all? Sorry, the Commissioner, I might have, didn't want to leave a little bit of time for that. If not, I'd love to turn it over to Mr. Moore for the corporate accountability report.
Good morning, everyone. The Corporate Accountability Subcommittee met Wednesday, September 10th. The Department's Advocate General, Joey Mickey, presented the Advocate General's report to the subcommittee and updated the committee on the work being conducted by his division. The report has been included in the board book. There were a few questions regarding the Advocate General's report that Mr. Mickey addressed. Mr. Mickey is present and available to answer any questions regarding his report.
I'd want to say thank you. Thank you for your good work.
Thank you. The Corporate Accountability Subcommittee recommends that the board accept the Advocates General report. I make a motion to accept the report.
Do I hear a second?
Second.
Thank you. Would you call the roll, please?
Mr. Einmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ali?
Yes.
Ms. Stomprud?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
The department's Deputy Inspector General, Carol Dennis, presented the Inspector General's report to the subcommittee. The Inspector General's report was reviewed by the subcommittee. There were a few questions regarding the Inspector General's report that Ms. Dennis addressed. A summary of her report is included in the board book. There was no further business discussed.
Very good. Thank you so much for your report and the hard work of everybody that goes into that. Okay, I'd like to then turn it over to Dr. Wilsey for the Performance Improvement Committee update.
Yes, the Performance Improvement Committee met on September 11th via Zoom. The medical directors for Griffin Memorial Hospital, Dr. Clayton Morris, and Tulsa Center for Behavioral Health, Dr. Scott Grantham, joined the meeting and to discuss medical care quality in an informal question and answer session. Ms. Tracy Lieber reviewed our critical incidents report summaries and circumstances surrounding these incidents and is here today if there are any questions. The Performance Improvement Subcommittee recommends that the board accept the critical incidents report.
Thank you as well for all of your hard work here. Do I hear, we have a motion. Do I hear a second?
That,
Thank you. Roll, please.
Mr. Einmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ali?
yes.
Ms. Stomprud?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
There was no further business discussed.
Okay. Thank you, Dr. Wilsey. Do we, yeah, okay. Dr. Henderson, you have a report for us? I'm sorry, doctor, yeah.
I'm not paid enough.
That's right, my apologies. You're following Dr. Moore here.
Oh, yeah.
Okay, the Finance Committee met via Zoom on Wednesday, September 10th. We were introduced to the new CFO, Ben Scott, who's with us this morning. If there are any questions, most of this is information that requires no motion. The new CFO, Ben Scott, did provide an update on the financial status of the agency. The FY '26 budget has been submitted. OMES approved the agency budget on September 10th. The department will work closely with OMES monthly, reviewing budget to actual activities. And FY '25 closeout remains in progress and is expected to be very close to finalization. Mr. Ron Miller did appoint Colonel Nathaniel Todd to this committee, and I don't know if you want to share any more detail about that, but.
The only thing I would add is Colonel Todd has a long history involved both in the military and with state government. He's been involved with Veterans Affairs in Arkansas, and retired Army colonel, had a lot of healthcare exposure while he was in serving our country, and has a pretty strong government finance background. I'm so excited to have Mr. Scott on board as our CFO, and hopefully Colonel Todd and anyone else that we can appoint in a short-term role that can give Mr. Scott the appropriate support through our finance committee. We certainly want to pursue that. So a lot of heavy lifting going on in this space, and to the commissioner's point, we're hopefully about to have approved budget and allow us to, sink our teeth in a little bit more on that. So thank you for.
No further business was discussed.
Thank you, Dr. Henderson. Okay, I think we'd like to move forward with a presentation from Mr. Snyder, if that's acceptable. Are you ready for that?
I think so.
Okay.
Mr. Snyder's here, so.
Okay.
Before he starts, I want to express my appreciation for Mr. Snyder to be here and do this. In my opinion, he's the state's guru on the Open Meetings Act and the Open Records Act, and so he may not appreciate that title, but I'm going to give it to him.
It's a big title, and I don't know that I'm old enough to take the we'll see. So I'm with the Attorney General's office. John and I work with each other at the Attorney General's office in the Legal Counsel Unit, which provides services to state agencies, including ALJ services, board legal counsel services, and regular general counsel services. Today I'm here in my capacity. I moved up within the agency to the general counsel unit and got the, present, if you will, of going around the state and presenting on the Open Records and Open Meeting Acts. And so today I'm going to go through this as quickly as possible. When I go around the state, this is usually like a 3-hour presentation. I promise you we're not going to go that long. So I hope you're caffeinated, because these are not the most entertaining acts to talk on. So we're going to move quite quickly. So one thing that I want you to remember when you're engaging in public business and you're having these meetings is that the act actually has a public purpose. And so every time that a case about the Open Meeting Act is litigated, the court is going to look at this purpose statement, which is to encourage and facilitate and inform citizenry's understanding of governmental processes and governmental problems. So how do we do that? Well, we encourage citizens to know more about public bodies and governmental processes and governmental problems. We post that advance notice with our record-keeping clerk. We post an agenda, and then we also have the responsibility of posting minutes online. And then second, how do we do that? We create a space where they can come watch. It's times and places convenient to the public. This is all statutory. So, what happened? My remote is being weird. Okay, so when does the OMA apply? So we have 3 prongs that has to be met for the Open Meeting Act to apply. A majority of a public body coming together to conduct public business. So here are what the public body is defined. There's multiple places where public body comes into, what different public bodies come. So here are some examples. For this meeting, we're just gonna say you as the board are supported in whole or in part by public funds, and you're talking about the transaction of public funds, the administration of public property, and you have actual or de facto decision-making authority. So in truth, you guys kind of cover all the elements of the Open Meeting Act. And here are some examples of the exempt entities. One of the things that, you know, I heard you talk about were your committees. Again, these are advisory, they're fact-finding, they're informational. These are not going to be subject to the Open Meeting Act under case law. And so we're going to move into, again, what is meeting defined? Conduct of public business of a public body by a majority of its members. What it is not is when you guys are gathered informally meeting. You're not coming together to conduct that business. You're maybe at an event. So conferences, receptions, church services, community events, and funerals. Now the state regents, to cover themselves, actually post agendas for when there is going to be a quorum present. And so this is what they do. This is a best practice. You don't have to do this, but I like giving this as an example for state agencies to look at and decide, hey, is this really something that we want to start incorporating? So a majority versus quorum. So the OMA default, the act uses the word majority. Interchangeably, quorum and majority are the same. You're going to have sometimes specific acts for boards, commissions, in state government that will have a set quorum. For example, I used to represent the funeral board. They had a 7-member board, but they had a statutory quorum of 3. Funny thing, that's not a majority of the board, right? Contradicts the OMA. It's specific to that board, and it's important because it's a very small industry, and so for them to actually take any actions, they sometimes have to rely on only 3 people to convene that meeting and actually take action against licensees. So here are other examples that I want you to remember. Your quorum does not decrease in light of a vacancy, except for, I think there's certain, I know the state regents are, not the state regents, Ethics Commission is one, and there's one other statutorily, but that's pretty much the only state body that your quorum does not decrease in light of a vacancy. And ex officio members can and should be included in your quorum count. They're just they are serving by virtue of their office unless they are excluded expressly by statute. So I usually use this slide across the state. I took out the names. I'm changing this up because, you know, I've used the same names for the past 3 years. And so I forgot to put them in. So let's just do this as an example. Let's use our favorite characters from Seinfeld. So we've got Elaine. She's going to send out an email to her fellow board members about an upcoming agenda item. Kramer has an opinion, smashes reply all. And then you've got Jerry, who has his opinion, smashes reply all to ask a question. And then finally, George Costanza has also something to say. He asks a question. They're all talking about, let's just say that they're a quorum. If they're all talking about the public business of the public body, they have triggered the Open Meeting Act. And so this is a technical violation, maybe not willful, but this is a technical violation of the act. And it's so important for you to realize that when you're using your digital devices, your emails, your laptops, etc., that you might inadvertently be triggering the Open Meeting Act. So be careful when using electronic communications, because it's also a violation of the act explicitly to circumvent the act by using electronic devices. So another thing that we ran into at the legal counsel unit is we had lots of boards that like to have that post-meeting lunch or dinner. I even had, I've heard of a municipality that tried to have one at a Sizzler. I'm not going to talk about the virtues of Sizzlers and other restaurants, but let's just say not a great place to eat, especially because if you're going there as a public body and you're in a quorum, you're actually possibly creating a violation because you have to pay to play, more or less, because you have to pay to get in, right? So if your public body, if your general public is trying to come watch you, make sure that you're not violating the act, they've got to pay to get in. So if you're going to do Sizzlers, just don't. But this is really the recommendation of the office, is to not have a quorum, go out to dinner or lunch after the meeting. separate. And if that doesn't work, I'll just let John use his deputy's general counsel to kind of space in between, making sure you guys don't talk. But that's kind of the best practice for this type of situation. So, conducting public business. What I want you to remember at that, this is not just that time period of when you are taking up action on a decision, long, policy. You are actually doing this through the whole process. So it is the entire decision-making process. Presentations of information, deliberation, decision, discussion, etc. It is the entire process. This is one of the imports that we brought from Florida. Not a lot of great imports from Florida, but this is one of the great imports from Florida. They have a very robust sunshine law, and so this is something that our courts have adopted and implemented within Oklahoma. I've already spoken to this. This is about using your device to circumvent the act. I understand convenience, just please don't use your devices to circumvent the act. So this is another important piece of law that came out in 2020 in the height of the pandemic. And it was a question from Representative Walkie, who asked whether a minority of a public body could meet outside of a public meeting consistent with the OMA. And so the short answer, because we're attorneys at the Attorney General's office and we like giving lawyerly answers, is that it depends. And so if the public body is doing so willfully to circumvent the act, we said, yeah, we see that a reasonable judge in one of Oklahoma's 77 counties could possibly say this is a willful violation of the Open Meeting Act. And so we thought, well, that's really not giving any guidance to our public bodies in Oklahoma. So here's your guidance. What you're not to do when you're doing meetings at a minority level is conducting polling or having discussions to reach consensus. This is your opportunity. I understand things come up. Our office understands that things come up in between meetings. This is your opportunity, or the staff's opportunity, to relay information. This is information delivery time. Here's this information. We didn't want to wait until the next meeting to give this to you. Do you have any questions? Yes. Okay. We'll try to get back with you. It is not an opportunity for you to look at your other board members and say, hey, what do you think about this? Do you think you're going to go yes or no? That is not okay. Because why? Our entire decision-making process is supposed to be transparent and open, and the purpose of the OMA is to facilitate public knowledge. And how do you do this behind closed doors? Okay, so I talked previously about, how we make sure that these meetings are, convenient to the public. So it's got to be open, specified times and places, convenient to the public. Here's an example. I only shame public bodies that have a case named after them. So let's talk about the Excise Board of Greer County. Excise Board of Greer County decided, hey, we're going to have a meeting, but we're going to have it on a state holiday in a locked courthouse. And so the court said, yeah, this is a willful violation of the act, and it demonstrated blatant or deliberate disregard by those who know or should know, if not willful and purposeful violations. So this is the case that gave us our standard. It doesn't just have to be a willful violation or purposeful violation. Within willful includes a demonstration of blatant or deliberate disregard by those who know or should know. So, I didn't want to get into a bunch of the intricacies of all these acts, so here's what I'm going to tell you. The main difference between a regular and special meeting is the notification to the record-keeping clerk. John knows this. Everybody who is going to be posting knows this. The only thing that you need to really remember is the new business allowed. New business is allowed on regular meetings. It is not allowed on special meetings. And new business has to be something that has come up that could not have been reasonably foreseen or known prior to the time of the posting of the agenda. So it's pretty much nothing is new business. So that's how I like to look at it. Emergency meetings, this is the least favorite meeting of any public body's attorney, but we understand that there are times in which you have to have one. I actually just gave some advice to a public body who wanted to call an emergency meeting or called an emergency meeting and said, hey, we had this emergency meeting because this guy was gonna go into surgery. And I'm like, no, that's not the standard for an emergency meeting. So you must first meet the definition of an emergency, which is a situation involving injury of persons or injury and damage to public or personal property or immediate financial loss when the time requirements of calling a special meeting would be unreasonable. So that is your definition that you have to meet emergency. Every time you go think about it and you're like, hey, let's do an emergency meeting, default to special. That's all I have to tell you. Continued or reconvene meetings. I understand that you may have long meetings that run into the lunch hour. Maybe you want to recess for the lunch hour. The best thing for you to do is to give notice of such action in the original meeting. So right before you recess, announce the date, time, and place of the continued meeting, or maybe you're recessing until the next day, posting notice on the website, and listing the updated agenda with remaining business items. So taking action, you guys are doing great. Your board secretary is doing what she's supposed to do. Votes are publicly cast and recorded. So I have nothing else to say here other than if you don't meet both, you do not have a valid vote. Okay, so executive sessions. Am I moving at too much of a clip? Do I need to slow
You're doing
down?
great.
Okay, good. Two important questions. Can I do it? How do I do it legally? Does it meet one of the bases under the 307B of the Open Meeting Act, or does it meet some other provision in Oklahoma law that allows for this? And then how do I do it legally? Is it posted on the agenda? Have I cited this specific basis under 307 or other Oklahoma law? Have I provided context as what we're going to discuss? Has the majority of the public body present voted to enter into executive session? So before we're going to have our vote, we're going to move into executive session. They are not authorized when you do video conference meetings. I know John well enough that he is going to protest to the nth degree if there's wanting to be a video conference meeting. Public vote to enter, cannot vote or poll in executive session. We recommend a public vote when you exit. So once you decide that you've wrapped up your executive session, pull everybody back in and then vote to exit. It's just a formality. That way you have something in the minutes saying you've entered, you've exited, etc. And then it's also a best practice for somebody to say that no votes were taken in executive session and no items not listed on the agenda for discussion in executive session were discussed. Of course, probably not a good idea if that is not the case. So here are the different bases. One, I want to highlight the first, which is discussing employment, hiring, appointment, or promotion, demotion, disciplining, resignation, termination of an individual salaried public employee or officer. That cannot be an independent contractor. So you cannot discuss independent contractors under 307B1. Discuss negotiations concerning employees and representatives of employee groups. This is a change under 307B3. You can now discuss the sale, purchase, or lease. I think it's a sale, lease, acquisition. It used to only be the purchase or appraisal of real property. It now includes the sale, lease, or acquisition. And then finally, this is probably the most important to you, confidential communications between the public body's attorney and the public body, which if you disclose the information or the attorney disclose that information, it would impair your ability to proceed in the public interest. And then finally, discussing information that is subject to confidentiality or privilege under state or federal law. So here are a couple of things that I want to talk to you about that I've run into. We had a very important executive public body of the state that decided to go into executive session to talk about a job opening. I'm not naming names. And then pending under 307B4, so that's about pending litigation, claim, action. That can mean anticipated or expected or potential. So what I like to say is, listen, if you get a litigation evidence hold letter or a demand letter, that is sufficient to enter into executive session under that basis. So I put it at the end. I probably should have moved this slide, but I'm really highlighting the 3 areas that public bodies get into the most trouble on. This is the one where the case law is. So, wording on the agenda shall identify all items of business to be transacted by the public body. If it's not on the agenda, you can't talk about it. So, and if you're going to have an executive session, you've got to include it. It's got to contain sufficient information for the public to know what the public body is going to discuss, and then identify items of business and purposes of executive session and state which provision of law 307 applies. Sorry, I'm getting ahead of myself. Okay, so wording on the agenda, plain language, directly stating the purpose of the act, and it's got to be simple, direct, and comprehensible to a person of ordinary intelligence. Our own legislature writes legislation to an 8th grade reading level, so that's what I tell everybody who is writing an agenda or agenda language. I say, if you cannot understand what is going to happen or have an idea of what's going to happen, and it's so vague that it's just not even sensible, rewrite it. So, as you work through the agenda, please know that there's nothing in the act that requires you to follow the agenda item by item. So if you want to mix it up, you can do that. Nothing in the act requires you to take up all items on the agenda. And finally, the act does prohibit you from taking action not noticed on the agenda. We already talked about that. So, for example, I list this little provision on my agendas. The public body, the board, may take up items in any order as it deems necessary and convenient. So we're going to talk about this case real quick. Everybody remember this case, the Norman case that came out? So the Norman City Council meets in 2020 to discuss an agenda item. They say on the face of the agenda they can either adopt or reject the budget. Attached to the agenda are 3 amendments, or 6 amendments. But there are 3 amendments that are passed out at the start of the agenda that are not attached to the agenda, and nobody knew about them until they were passed out. So the Fraternal Order of Police, and they adopted them. So Fraternal Order of Police sued, alleging a violation. The trial court found against the city of Norman, concluding that the city had violated the OMA and granted summary judgment. Summary judgment is a big deal because that means there was no genuine dispute of material facts, and that the moving party was entitled to judgment as a matter of law. So City of Norman appealed. Don't ask me why, because I don't know to this day. And the Oklahoma Supreme Court retained the appeal. Now, it has been my experience when they, on their own, retain the appeal, it's not a good thing. So OSC affirms the trial court finding the City of Norman violated the act. They said, look, you wrote the agenda to where you could only adopt or reject. You didn't allow for amendments. You didn't allow for anything else. You could adopt what was on the face or reject it. And the court further said, the way it was written is deceptively vague or likely to mislead, thus making it a willful violation. So best practices, don't limit the agenda to just adoption and rejection. We recommend using possible action, and I have little language that I like to include at the end of my agenda to define what possible action may include. Indicate or cite your supporting documents if you can, if they are ready to go at the time of posting. And if you have sufficient time, please list the amendments if you have the amendments on hand. And remember, as you're drafting the agenda, or if you're helping draft the agenda, or kind of part of that collaborative process, the expression of one thing excludes others. So be more inclusive than exclusive, because what do we remember? You can't take action on an item that is not on the agenda. So, possible action. This is my way of taking up the mantle of saying, okay, possible action, it includes all these possibilities, and that is my way of giving some kind of meaning to that phrase. So Hirschfeld, this is another one in which the Turnpike Authority used some pretty vague language, but at the end, the court said it wasn't a willful violation because the action that they were taking was only on financing and not on actual approval. So the kind of key phrases that I want to highlight for you are using a phrase like certain turnpike projects. So don't know where they are. We have multiple turnpikes all over the state, new, and it doesn't really provide sufficient notice, in my mind, personal opinion, of if it's a new project or if it's a, or a new turnpike or if it's a existing turnpike. So then they have a subsequent meeting in which they have a phrase, various turnpikes. And then they also refer to the Access Bond Program. None of this has been announced. Nobody knows what this is. So they're using phraseology and, these terms that nobody knows about. And so finally, during the director's report, Governor Stitt comes in, gives his big presentation. This is the first time the public knows what exactly Access Oklahoma is. So landowners, residents are pretty ticked. They sue OTA. It goes up on appeal. Judgment was reversed and remanded with instructions in favor of OTA. So sufficient notice was given. It was all about the financing. This is a highly technical opinion. But I think it's important for you to remember that it's not okay to use the vague language that they did. I've read the opinion multiple times. I don't think the court really tackled the issue of that language. So, never use anything like certain turnpike projects when you're doing a director's report. If you're going to have any major announcements from somebody other than the director, it's also a good idea. The court actually pointed this out in the opinion that it would have been best had they listed that the governor was going to be there. And then finally, always label non-finalized plans. And I think this is what really they were trying to protect against, is if they actually labeled everything and put something out there that people are going to say, oh, this is it, this is what they're going to do. I think one way they could have tackled that is by saying proposed, draft, preliminary, something like that. But they just didn't want to put that out there. So this came up this year or last. It's about legislators and executive sessions. Importantly, what I want you to remember is that it's any executive session authorized by the Open Meeting Act of any state agency, board, or commission. So this doesn't include anything below that. And then whenever the committee has jurisdiction over the public body's actions. Incredibly broad, could mean multiple committees. So we are going to say let the legislature, have that decision-making authority on that. Okay, why should I comply? Actions that are taken in willful violation are invalid. Minutes of executive session, if that is a part of the violation, are going to be released. And any person, that means any person in Oklahoma, can bring an action and sue a public body. And if they're successful, they are entitled to reasonable attorney fees. And I will show you how expensive that can be in a moment. And then criminal penalties, any willful violation if convicted is a misdemeanor, up to a $500 fine, 1 year in the county jail or both. So we remember the fraternal order of police case. So at the end, once the court issued its order, the fraternal order of police went to the court and said, hey, we want attorney fees for both the appeal and trial court. And so it went back, they remanded it back down to the trial court to do a hearing on, what the costs were. And shortly before there was going to be a hearing, the city of Norman ended up paying about $44,307.00. Now, granted, we didn't get into the financial details of this agency, but I can tell you that hurts a small school district, it hurts small municipalities, and it's not going to be an easy hit on the chin for a state agency, no matter who you are. So it can be expensive. And then finally, this is an example of a more local county official. He was a former county official. He was indicted by the Office of the Attorney General's multi-county grand jury. and he was found to have violated the Open Meeting Act. He ended up pleading guilty on charges on September 25, 2023 in exchange for a 3-year deferred sentence, but also serving 45 days in the county jail and had to pay about $10,000 of money. He was not entitled to extra credit. That was a finding of the judge, and the judge also said, while you're on this sentence, you cannot work for any government entity. So he basically is forbidden to work for federal government, tribal, municipal, county, any type of government he is forbidden to serve. We've talked about our standards of what constitutes willfulness under the act. You know, it's not just the showing of bad faith, malice, or wantonness, but encompasses that conscious, purposeful violations of law or blatant or deliberate disregard of the law by those who know or should know. And then if you have an agenda, like we talked about, that's deceptively vague or likely to mislead, that also is a violation. Bailey versus State, the summary on this case is if you're gonna make a challenge to an Open Meeting Act violation, you actually have to show evidence of willfulness. Forgetting, you know, without intent to violate the act is not going to make a willful violation. So I include this too. So when you get challenged on this, and this is why it's always good to just follow the rules, you're walking into court with your hands behind your back. The statute is liberally construed to further the act's goals and in favor of the public, and there's only strict compliance. There's no such thing as substantial compliance for the act. So you are walking in with your hands behind your back, and there's a great possibility that you're going to lose in an Open Meeting Act violation case. So you really can't unring that bell, right? You've committed, if you've done something that is not according to the act, it's kind of invalid, so you're gonna have to just take the action again. So correcting is, you know, the term in air quotes that I use. So post your advance notice, post an agenda timely with accurately worded agenda item, take up the item, revote, and record the decision. So again, we've talked about all three. These are the top three areas of the Open Meeting Act that we see at the Attorney General's office with a public access counselor, or they email me directly, and it is, you know, oh, well, we weren't technically meeting. Well, let's talk about that definition of conducting public business. Oh, that's not good. 2, executive sessions. Very misworded executive sessions or a misuse of the executive sessions and violation of normally 307B1 is probably the most abused, surprisingly. And then finally, agendas. Deceptively worded agendas or misleading language is a big one. So we're gonna go straight to open records. I promise I'm trying to make this light on you guys. So this is a different act because it has a public policy and a public purpose. So the public policy of the act, again, like I talked about, these two things, if you are going into and defending a action for violation of the open records, the first things that the court are gonna look at are these two provisions. So the public policy, Oklahoma citizens have a right, an inherent right to know and be fully informed about their government. And then the purpose of the act is to ensure and facilitate the public's right to access and review government records so they may efficiently and intelligently exercise their inherent political power. That inherent political power is derived from the state constitution. I think it's Article 2, Section 1. So it is steeped in the Constitution. So what is a record? What I want you to remember from this phrase is the definition of record under the Open Records Act says include but not limited to. It's our phrase for lawyers when we, you know, like, well, something may come up in the future and we want to make sure we cover it, so we're going to use this all-encompassing phrase, and it's just going to, like, you know, be a Pac-Man for perpetuity. So this is exactly what lawyers love and hate. So it's a document. We'll talk about what documents are included. That is created by, received by, under the authority of, or in the custody, control, or possession of public official, public body, or their representatives, public employees. For everybody at ODMH listening, you're included in that definition of a public official. And then finally, in connection with the transaction of public business, expenditure of public funds, or administration of public property. So as you can imagine, that encompasses quite a bit of what you guys handle when you get something from this agency. So just be careful, and we'll talk a little bit more about your agency-specific statutes. So here are some examples that are included within documents. I want to call the attention to emails and text messages. We have 2 AG opinions. So your electronic communications, what I want you to remember, if it's on a state device, that's great, because usually the records team can get that quickly, but if it's on your private device and it's a public record and it concerns anything that we just talked about, you might be getting an email or a call saying, hey, we just got an open records request, and it was directed at you, and we need to talk about what records you may have or may not have. So again, we're just going to say, yes, you're a public body under the Act, and here are examples of what are included within public bodies and officials. So what is not a record? Computer software and non-governmental personal effects. And thank you, legislature, for not defining what non-governmental personal effects are. So, when the record meets these broad definitions and language, it's going to come under the Act. Nonetheless, it can be shielded from disclosure if exemptions or an exception applies. So here are the many exemptions to the Open Records Act. One of the most important ones for you is actually not on here. But what I do want to cover real quick is when you do have a meeting with John, I want you to remember that he has a qualified attorney-client privilege. Under state law, attorneys for government agencies, public bodies, only enjoy the privilege when the communication concerns a pending investigation, claim, or action when disclosure will seriously impair the ability of the public officer or official or agency to conduct the claim or process the claim, pending investigation, litigation, or proceeding in the public interest. So again, what I want you to remember is that as you're talking to them, if you're talking about one of these type of things, you're probably going to be covered. But if you're not, there's a likelihood that the privilege may or may not apply. So for John and you, I did some digging, and here are some of the information that is directly under 43A that you are covered. So treatment information is privileged and confidential, which means it is confidential under the Open Records Act, can't give it out. It is privileged for the purposes of litigation, meaning it can only be waived, and it really can only be waived by the consumer or the consumer's advocate. So identity of consumers or patients, privileged and confidential. Your access to information is limited, so it's only if you have a need to know, basically. So for the staff performing the treatment or services, or the person doing the administrative work related to that. And it's limited to, again, only the information necessary for them to carry out that function. So cannot be disclosed to another person except as authorized under 1-109. Release for disclosure of information must be signed in writing. There's a whole statutory list of what has to be in that release. And then a subpoena is not sufficient to get a release of that information. You actually have to go to a judge and get an order. So investigations into care, these are also confidential and privileged, and those records or information that are included, any information about those investigations into care, records, materials, reports related to the investigations, allegations of consumer abuse, neglect, or mistreatment. So the inspection and release of these records are only permitted to be released after court review, and the court determines that there's a compelling reason to waive the privilege in the public interest. So they have to do a whole order, findings of fact, conclusions of law, as to why release of that information is of the public interest, and it has to be a compelling reason. So you were allowed, or I should say the department is allowed, to summarize allegations, facts, and evidence, and findings. The report itself seems to be confidential and can only be released to certain persons. The Advocate General and Office of Consumer Advocacy, again, confidential and contains privileged information. So what they're kind of saying is here, not releasable under the Open Records Act, and there are certain portions of that that may not be released under subpoena or court order without that finding. Again, it follows the previous section. If you're going to release that information, a judge has to review it and then subsequently make an order finding that there's a compelling reason to waive the privilege, as well as there is a public interest in releasing that information. Again, Advocate General and Office of Consumer Advocacy have the ability to release those summarize allegations and release that report to only certain persons. So for oversight, management, and evaluation, so this is to collect information to help the department provide better services and combat and prevent mental illness and substance abuse. So your individual forms, computer tapes, and other forms of data are confidential and not subject to the Open Records Act. Importantly, that would still be under subpoena-able, or could be asked for in discovery, or could be court ordered. And then finally, generally identifying information shall not be disclosed and shall not be used for a public purpose. So here are some exceptions that you will likely run into. We've already talked about a couple of them. I want to highlight this one. This is new as of 2021. Usually, the public body was able to say, we're going to hold it confidential, and there was pushback and pull between the court, requester of that record, and then the agency or public body wanting to keep one of these types of records confidential. In 2021 or two, the legislature passed a new version of this into law, which says, subject to the sole discretion of the public body, it may keep personnel records confidential in two situations. So you have internal personnel investigations, except when there's been a final disciplinary action resulting in some type of action, so termination, loss of pay, involuntary demotion, punitive transfer are examples, and in cases when disclosure would warrant an invasion of privacy. So personnel bodies, though, have to use a balancing test to weigh the public's right to know against the employee's right to privacy. These are things that are actually protected: an employee's ID number, an employee's social security number, and then home addresses, home telephone numbers, social security numbers, private email addresses, and private mobile phone numbers of current and former state employees. However, nothing, and they wanted to underscore this, nothing under this provision allows you to keep those records when you're operating on those private devices and private emails from being producible under the Act. So, except as may otherwise be confidential by statute, so if a public body, for instance, wanted to say, no, we're in the middle of an investigation, we haven't taken anything final yet, when they have an investigatory report, they could hold that confidential and public employees wouldn't be able to access that, but generally they do have an ability to request access to their file, except for those files the agency determines confidential. Personal notes may be kept confidential, and personally created materials prior to taking action. And so remember, as you're destroying those, be cognizant of the records retention schedule. If you have any questions on that, reach out to John. Another item is when federal law requires the record to be confidential. We have a provision in there making sure that if there's a federal law, maybe it would not be confidential under state law, but you have a federal law saying it's confidential. We have a state law saying that in that instance you can keep that confidential. Given the headlines, I wanted to make you aware of this one. I don't know if you have received anything of this matter, but personal communications related to the exercise of constitutional rights under the Oklahoma Constitution or the First Amendment. So if somebody reaches out to you and says, hey, I have something to tell you about this, I want to speak to you, you can keep confidential the contents of any communication that you receive and their contact information, their identity. Now, if you do a response, you can keep their information confidential, but you do have to produce that response. Is that clear? You guys are glazing over, which is expected.
I have a question. Does that imply that you have to produce the response, but do you have to produce the original information?
No,
Just
so
the
like,
response.
so the
Okay.
complaint coming into you or the communication going to you, all that can be kept confidential. It's just the response
Okay.
is producible if
Yeah.
requested, but you can de-identify it. So there's a new section that you may or may not know about under 24.8.34. I think this is something for you guys to know because you're in the mental health space, that a licensee who has mental health records that are enter into an individual proceeding, say they have committed an act of, or allegedly committed an act of unprofessional conduct, a licensing board is wanting to take action, and they say, hey, I have a mental health diagnosis or I have counseling records that I want to enter into evidence or add a part of the record, you can do that confidentiality. And it can be a part of the record as part of the application process or the individual proceeding process. And so what you can do to that is you can also restrict who can get those records once they are in possession of that public body. So I think this is a really great provision for public bodies because they were kind of having to stretch a little bit on how they can maintain confidentiality of these records. And the best part is that when they retire or resign from practice, the licensee can actually go to the public body and say, please destroy those records out of my licensure file. So the production procedures, I only talk about this because as John or somebody from records, I don't know who is in charge of your open records program, but what I want you to know is here's kind of like the roadmap of how these are done, and I'm highlighting what you need to know in order to assist them to get that records request closed. So timeline for responses. Other states are like, you got 10 days, you got 30 days. Our state said, look, we're not gonna lock down public bodies. There has been many attempts to do so. But what we're gonna also say is, you have to provide the records in prompt and reasonably. Prompt reasonable access, there's multiple ways, copying, printing, and inspection. The answer is always going to be contextual when you have a records request. And so maybe it's a gigantic, voluminous request over a period of years. That's going to take some time. And so you're going to have a little bit more time to fulfill that if it's over a period of years and there's multiple search terms and it's encompasses a lot of stuff that is within your possession. If it's a recently public document that's not on your website, but it was made public, and you know it's existing, then you have to produce that rather quickly in my mind. If it's just one document, that's all they're wanting, that's got to be produced quickly. So redaction is permitted to the extent that there is privilege or confidential information within a record. The public body has the authority to go in and segregate the portions of the record that are confidential and privileged and produce the record as redacted. And then, this is the other thing, and John is probably teaching everybody about this one because everybody loves to be helpful in state government, for the most part. We have those people, we love them. But this is one of those people who's extra helpful, and you go to them and you say, hey, I really need something that says this. Okay, let me make it for you. No. Only a record that is existing. If we don't have a record that exists, you don't have an additional record keeping requirement. So if they come to you and they say, do you have this record? You do not have a responsibility under the Act to create a record to meet an Open Records Act request. Is that clear? Did I make that muddy? Okay, and so here's kind of the diagram of the request process for you to know a little bit about. I think it's important for y'all. And then finally, civil and criminal penalties. The requester must be denied access to records of a public body or public record or official. What I want you to remember about this, though, is that we have seen multiple cases now in which courts in Oklahoma will entertain constructive denial, meaning you have not provided the record. They've not given a definite denial, but you've also not been providing prompt reasonable access. So plaintiffs, requesters are saying, hey, you've constructively denied my request by not providing the records we've requested in a prompt reasonable manner. So usually you used to be able to just go to court, file a motion for declaratory injunctive relief. If you were successful in that endeavor, you were entitled to reasonable attorney fees. If the public body successfully defended the suit and the court finds that it was clearly frivolous, they can get reasonable attorney's fees. What you need to remember though is, and I remind our public bodies of this all the time, that suit only is tied to what has been denied. If they have subsequently filed another request and they are trying to rope that in with the case, they cannot do so under 24A.17. But now, here's the change. This came last year. If you're going to sue a public body for violating the Open Records Act civilly, you have to give them 10 business days notice. And then if, hopefully, and that notice goes to us, and hopefully in the meantime, our public access counselor or I will call that public body and say, hey, let's talk about this, let's get it produced, let's get it running, and you won't get sued. That's, the best plan. Criminal penalties, I have not found, to my knowledge yet, a prosecution of a person for willfully violating the Open Records Act, although I am working with a public body / public official / requester, and I think there is a total criminal violation right now, because they're flat out refusing if another body doesn't produce the record. So, let's just put it that way, that I have seen for the first time what I think to be a criminal violation. So if you are prosecuted and convicted, you can be required to pay a fine of up to $500, imprisonment, and the county jail for up to 1 year, or both. Kind of a crappy deal if all you're doing is denying a record. Meaning it's not worth the record denial.
For the record, that's not this department.
I'm not trying to put that on John. Anytime I've contacted John, we've had somebody call, he's been awesome. So, 5 stars. You're not getting a Yelp review. Any questions?
So what you just presented is on,
So yes, this is a fulsome actual presentation. Oh, so this is our it's on that webpage, sorry. Yeah, so the 2024 presentation that I give across the state that's over 100 slides and is very comprehensive, that is online. So you can go find that. It will be updated. We had a couple of updates to the Open Meeting Act, actually just one, and then several updates to the Open Records Act, so that'll be updated this year. So.
Mr. Schneider, I want to thank you. It's like when the deputy sheriff over here, who is constantly monitoring my speed limit, invites, the head of the state police in. So thank you for sharing
We
your.
promoted him.
Thank you for your time and all the work you do. Okay. Under new business, after that inspiring commentary, I don't know that I have much to offer other than, as we mentioned, we are contemplating some individual appointments to both our corporate accountability and finance subcommittees. So if you know folks in those spaces that are of interest, I would say to the board, let me know. Happy to, if someone is interested and you think they have relevant experience, happy to have that conversation. Hearing no other new business, I'd like to ask that we adjourn and reconvene in the Real Property Trust.
so moved.
Do I hear a second? Call the roll, please.
Mr. Reimiller?
Yes.
Mr. Moore?
Yes.
Dr. Ellie?
Yes.
Ms. Stomford?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
Okay. Calling the Real Property Trust Board meeting to order. Do we have a quorum here as well?
Yes.
I believe we do. Okay. I would like to get the minutes approved from our previous meeting on July the 18th. Have everybody had a chance to review that, and do I hear a motion to approve?
I make a motion.
Thank you. And a second. Thank you. Would you call the roll, please?
Mr. Reimiller?
Yes.
Mr. Moore?
Yes.
Dr. Ellie?
Yes.
Ms. Stomford?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
Okay. Mr. Carden, walk us
morning,
through
Chair.
a couple of items to hit today.
Yes, yes. So, first item, will be, the approval of the land on 13th and Lottie. And so, to start with, I have provided everybody a general timeline of this project. And pertinent to this discussion, I would like everybody to see the second page, September 26, 2024. This was the real property trust meeting in which Mr. Ryan Miller moved to accept a motion to allow ODMHSAS to enter into a letter of intent to sell the 13th and Lottie property to the city of Oklahoma City. October 1st, 2024, the letter of intent was created and sent to the city of Oklahoma City. And so furthermore, in the second attachment in the packet, in the paragraph labeled financial terms, you will see it reads as the city will execute a 90-year lease term with the department and whatnot. So within this verbiage, the city has rejected the letter of intent that was originally sent. The city requests that the letter of intent reflect the draft real estate donation agreement verbiage, which would be the third packet, or third attachment in your packet, to where we have agreed to sell the property to, or we had agreed to donate the property, in which we cannot do. And so so today, that's what I would like to ask for approval on, is to sell the property to the city of Oklahoma City for $1.
I feel like I have questions and I don't know what they are. We started off with the expectation was we were gonna, have significant revenue generated from the sale. Is that?
This is the property on 13th and Lottie, in which it's part of tied to a MAPS 4 project
Oh, that's
for
right.
Oklahoma City to build the crisis center. So, yes, the request to sell the property for $1 to the city of Oklahoma City and return for a brand-new building for the crisis center, which will house our current facilities, Oak Crew and Oak Kick.
Got it. Thank you. I sometimes need a refresher course.
And where that would be, like, where would it be transferred, like, which area? Like, so we're selling this place, I mean, are they gonna rebuild the same area, or, I mean, we're moving it to?
Yeah, yes, correct. Very good. Yes, I understand your question. Very good. We are going to transfer the property, 13th and Lottie, to the city of Oklahoma City, in which they will build a building on that property for the Department of Mental Health and Substance Abuse Services.
So other than the fact, this is exactly in line with what we intended, other than the fact that we cannot donate it, we have to sell it for $1.
Correct.
Okay,
So that is really the correction we're making here.
got it.
Yes.
Mr. Chairman, if I may, we will be given the building, but we will be responsible for not maintenance, but the labor,
Yes, operating the building.
operating it. So that will have to be worked into our budget as well.
Is that part of our budget at this point?
Well,
It's being approved?
it will be part of it, and again, the building, as Chad mentioned, probably won't be ready until next fiscal year, roughly. Is that right, Chad?
Correct. And currently, they're in the 95% stage of the drawings, with intentions to start construction early part of next year.
So 27 budget,
Yeah.
but we'll have to make sure that everyone's aware of that and we're covered.
Absolutely.
Right.
And so furthermore, this building will consolidate two of our locations, Oak Crew and Oak Kick. So those buildings are already in operations with teams. Both of those teams will move into the crisis center. And the win for the agency will be getting out of a long-term lease where we've been operating Oak Kick.
Bravo. Thank you for highlighting that. Any other questions? Pause for effect. Hearing none. Okay. Do I hear a motion to approve the potential sale of the Culberson Heights property?
I make a motion.
For $1,
In the best
Oh,
interest
yes,
of
yes.
in the best interest of the state of Oklahoma.
Yes, sorry. Stopped reading too soon. Apologies, that's my fault. Good thing my sheriff is here.
Deputy Sheriff.
Deputy Sheriff, okay. So we have a motion to approve the potential sale of the Culberson Heights property as previously described as in the department's best interest. Do I have a second?
Second.
Okay. Call roll, please.
Mr. Reinmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ellie?
Yes.
Ms. Stomford?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
All right, Mr. Carden, as if that wasn't fun enough, let's move to the Mohawk Boulevard property.
Yes, very good. So we did approve in the last real property trust to move forward with auctioning these two properties. So on September 5th, the sealed bid auction was closed and awarded. The first piece of property containing the building on 5 acres appraised for $705,000, and the winning bid was $710,000, so $5,000 over the appraised value. The second piece of property was the vacant 5-acre lot. It was appraised for $185,000 and sold for $200,111. So that brings in a total of $20,111 over the appraised value for both properties. And so-
Fantastic. You have a hard bargain.
So,
We obviously know, are we allowed to say who that went to? Is that,
Oh, yeah, I think that's.
yeah, and I'll comment, this was definitely a win-win for the state of Oklahoma and the programs that we continue to support here at the agency. Palmer Continuum, we built that building over 20 years ago for Palmer Continuum. They've always occupied it, and so they did win the bid. So,
fantastic.
good for the agency, state of Oklahoma, good for Palmer Continuum.
That's a win-win, absolutely.
And the Tulsa Women and Children's Center that is housed there.
That's already there, yeah, okay. Okay, well, in light of that, any discussion, questions on the board? No? Okay, in light of that, I'd like to ask for a motion to approve the potential sale of the office building on Mohawk Boulevard as previously described as in the best interest of the department.
I'll make a motion.
And do I hear a second? Awesome. Call the roll, please.
Mr. Reinmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ellie?
Yes.
Ms. Stomford?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
Very good. Mr. Carden, thank you for, you've done a lot of juggling on all these projects, so thank you. I know it's not been easy. We appreciate all your work.
Thank you, Chair.
All right. I'd like then to, I believe we need to ask for a motion to adjourn. And do we do not need to go back on, I guess?
Nope.
No, we're done. Okay, so,
Motion to adjourn.
motion to adjourn? So moved. Do I hear a second?
Second.
Second. Call the roll.
Mr. Reinmiller?
Yes.
Mr. Moore?
Yes.
Dr. Ellie?
Yes.
Ms. Stomford?
Yes.
Dr. Wilsey?
Yes.
Mr. Henderson?
Yes.
Thank you all.